All right. Well, welcome to the Arizona Lien Waiver webinar presented by Lien Services. My name is Bridget Nielsen, and I am the operations manager here at Titan Lien. I have been part of Titan Lien Services and its predecessors since 2011. So I'm going on about 14 years now involved in this industry. To start, I just want to acknowledge that we all know this one thing, and that is that no one construction job is like another. And sometimes it's really hard to know what to do when you are asked to provide a document, a waiver and release, that could take away all of your lien rights. So there's a lot of anxiety around waivers, and we are doing this webinar to help alleviate any anxiety by providing education and best practices when it comes to lien waivers. This presentation will be recorded. I will go through the entire presentation, and then we will have a breakout session for your questions. We love to have the interaction, the one-on-one. We'd love for you to share specific scenarios that you're facing, and maybe we can give you some suggestions. If you are watching this webinar after January 22nd, 2025, there will be no breakout session, and you can contact our offices and we will do our best to help you out. Okay. Here's our disclaimer. Titan Lien Services is not a law firm. I am not an attorney. Nothing included in this presentation should be considered legal advice. The information contained is directly from Arizona state statutes, or it has been taken from legal presentations and discussions that I personally have had with Arizona construction attorneys. This presentation is not a substitute for the advice of an attorney. Although every effort has been made to ensure its accuracy, Titan Lien makes no warranties, express or implied, or representations as to the accuracy of content on this summary. Now, there is a lot of confusion around the word release when talking about liens, and I'm going to explain this right now. So a waiver and release is one document. It has those two words in it. It's not two different things. It's one document called a waiver and release. It waives and releases your lien rights. In this presentation, I will be referring to them as just waivers, just to shorten the title. So when I say waiver, I really mean a waiver and release. All right, and these waivers and releases are typically only used when you have received a payment or when you are about to receive a payment. If you send preliminary notices to protect your lien rights, which everyone should be doing, you may be sent a waiver and release request monthly by your client or by a request from the general contractor. Now, a lien release. This occurs only after you have recorded a mechanics lien at the county recorder where your project is located. A lien release releases a lien on the property, and it must be recorded at the county level. A waiver and release, even though it's not recorded, can be a very dangerous, legally binding document because it waives your lien rights. Whereas a lien release, when it is released, you still may have lien rights. Okay, do you see the power in a waiver and release? And I can understand why there is a lot of anxiety around that. So that is the difference. So when people call our office and say, I need to release a lien, a lot of people say that when they really just mean they need a waiver and release on a pre-lien because they sent a preliminary notice and they've never done a mechanics lien. So using the word release can confuse us, and we really need to get clear on what you're looking to do. So waiver and release is what is not recorded, and it is used when there's no lien on the property. All right. Just as you have lien rights, owners also have rights to protect themselves, and they use waivers to do that. They can require you to provide a lien waiver and release. Here is the language that's required on all of the 20-day preliminary notices here in Arizona. This is on all of your notices, okay? And these waivers are required of you when it is requested of you. Now, if nobody asks you for a waiver after you've done a preliminary notice, you are not required to provide this information. I want to read this and go through this because I think it's really important that everyone understands that just as you have rights, owners have rights. Okay. This is a notice to property owner. If bills are not paid in full for the labor, professional services, materials, equipment, machinery, fixture, or tools furnished or to be furnished, a mechanic's lien leading to the loss through court foreclosure proceedings of all or part of your property being improved may be placed against the property. You may wish to protect yourself against this consequence by either, and here are their options. Now, look at this. You may wish to protect yourself against this consequence. This is their right. They can do it in two ways. They can require you, the contractor, to furnish a conditional waiver before you make payment, or they can require an unconditional waiver after they make payment. Okay. Conditional is used before you receive a payment, and an unconditional waiver is used after you receive payment. Here in Arizona, we have statutory lien waivers, which means the legislature has created and set the language and the templates that should be included in the different waivers. We are going to discuss many aspects about each of the waivers and what to be aware of. We're also going to address scenarios where you may need to edit the waivers minimally in order to protect your lien rights. You can always do a Google search of just type in ARS, stands for Arizona Revised Statute 33-1008, and you'll see it. And okay, so before I go into some of these, I want to just kind of go over definitions so we're all on the same page about what some of these words mean. So conditional. Conditional is a term used when a contractor has not received funds into their financial institution. You notice I didn't say did not receive funds like a check in their hand. A check in our hand is not the same as receiving funds in our bank. Okay? If funds are not in the bank, you should use a conditional waiver. Unconditional. This is a term used when a contractor has received payment and it has cleared the contractor's financial institution. A progress payment. This is a term to convey that the contractor is still active on the project, or they may return to the project in the near future and they expect future payments. Final payment. This is a term to convey that the contractor's work is complete, and this represents the last payment to be expected. Disputed claims. This means that an owner or contractor must have actually disputed and must be continuing to dispute an obligation to pay for the charges. The word extra work comes up in one of the waivers, and this means materials supplied or labor performed that is part of a change order. So we understand extra work to mean change order. All right. Now, this is a page I will, at the end of the presentation, share with you a PDF, and this is one of the pages as part of it, but you're welcome to take a screenshot of this. This, I think, is really helpful. So if someone's new to providing waivers, these are the different scenarios as when you should provide which waiver, okay? Conditional waiver and release on a progress payment. You, the contractor, is still on the job and you're waiting for a payment for a certain time period. You're not done with the job. It's maybe for last month, okay? Then an unconditional waiver and release on progress payment. You, the contractor, are still on the job and you have been paid for services and materials for last month. And you would provide this waiver. Conditional waiver and release on final payment. You, the contractor, you are complete with the job and you are waiting for your final payment. Unconditional waiver and release on final payment. You, the contractor, you are complete with the job and you have been paid in full for the entire project. When you are asked to provide a waiver, you can refer to this to determine which waiver is required. A lot of your clients might send you documents, waivers that are partially filled in. I highly advise you to review this, to review the language in it, even if it's a lot of people from out of state, maybe a GC's, maybe out of state, and they send you their state's waiver. Every state has different waiver requirements, and some states have no waiver requirements. Arizona is one of those where it is statutorily required to be substantially the way the legislature has laid out. All right, I'm going to start going into the items to be aware of. So on unconditional waivers, something to be aware of that this mistake is made quite a bit, okay? I want you to know that at the bottom of every one of your unconditional waiver and releases, there is a warning to you, the signer, and it is required to be on the waiver, and it states this: this document waives rights unconditionally and states that you have been paid for giving up those rights. This document is enforceable against you if you sign it, even if you have not been paid. If you have not been paid, use a conditional release form. They're warning you on all of these. If you have not been paid, don't sign this. Okay. Now, there's a warning for conditional waivers. Conditional waivers become unconditional waivers once the funds have been received by the contractor, as stated on the conditional waiver. I'm going to give you an example of a waiver. This I just took right from the state statute, so there's some instructions in here, so we can just ignore and pass over those. So like, for instance, maker of the check, that refers to this line. And that's why I actually do like the templates right from the statute, is you can see what goes in each line. Sometimes there's a blank and you're like, what do I put there? So they have that information. So you would put your project name, a job number, if that applies. And so here's a conditional waiver. On receipt by the undersigned of a check from Reds Contracting in the sum of $10,000 payable to Ridge Concrete, and when the check has been properly endorsed and has been paid by the bank which it has been drawn, this document becomes effective to release any mechanics lien, any state, any other rights, okay? So let's say that you receive the check for $10,000 and the check clears your account. This waives all your lien rights unconditionally for the whole project, because this is for the final payment, okay? You're done with the job unconditionally. Well, you realize you made a mistake and they actually owed you $13,000 because you forgot about a change order. And you actually deposit the $10,000 check. You have no lien rights for the balance. Okay, so let's say you complete a conditional waiver and you receive the check and you realize you made a mistake. Don't cash the check. You can return the check, revise the waiver, but as soon as you cash that check, this becomes an unconditional waiver. So be aware of that. A lot of people think it's not a big deal if it's a conditional waiver. It's safe. Well, may not be. Could hurt you. All right, progress payment waivers. These waivers are the ones that actually require sometimes editing of the waiver. And you're allowed to do that in Arizona to help you protect your lien rights. And sometimes it is absolutely necessary. Okay. The legislature can't think of everything. They may not be contractors and people in the construction industry helping to draft them. It's not perfect, but it is the laws that we go by. All right. I'm going to take an excerpt from a progress payment waiver. And I want to explain what we call a through date. So in the middle of the waiver, it says this release covers a progress payment for all. Do you see that word all? Labor, services, equipment, or materials furnished to the job site or to our contractor through December 31st only, and does not cover any retention. Okay. So basically, you are releasing all labor up through December 31st. All right. Now, let me give you a scenario. I think it's really important to have an actual scenario or a story to share with you to go through a real life example. Now, this isn't real life example, but it is something that's very feasible. So the story is this. You do work in June. You have a June 30th invoice for $12,000. You do work in July worth $10,000, and you have invoiced your client. You have an August invoice. They're not paying you. You have a conversation with your client. Your client's, oh, yep, I'm cutting you a check for the $15,000 for July and August. I'm getting that out right now. And then we just had a few questions on the June invoice. It's currently being reviewed, but we're going to pay that as soon as that gets approved. I don't see any issues with that. So could we get a conditional waiver for the $15,000 from you? Seems perfectly fine. Sure. I'll give you a waiver for $15,000 for those other two. They're cutting the check right now. Okay, but we're going to give you a conditional waiver, right? Because the funds have not been received in your financial institution. Seems safe. So here is the waiver that they create. On receipt of the undersigned of a check from Reds Contracting in the sum of $15,000 payable to Ridge Concrete, blah, 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 details of the job. This release covers a progress payment for all labor, services, equipment, or materials furnished to the job site or to Reds Contracting through August 31st. Seems fine, but I want to share with you that through August 31st has more power than this $15,000 in a lawsuit. This comes from a discussion I have had with a prominent construction attorney here in Arizona. A judge is going to look at this date before they look at this date. If you sign this conditional waiver and they pay you the $15,000 and you deposit it, it becomes an unconditional waiver, and you just waived all your lien rights for June's invoice. You could never file a lien ever for this amount based on that waiver. Now, an attorney might say, oh, we're going to write a letter voiding this, right? That's something an attorney would have to do. There might be something that an attorney can do. We cannot do that. And we can't make that call. We don't know that. So something that seems so simple and so cut and dry can really hurt you. And you just lost lien rights for $12,000. Now, just because you lose lien rights for $12,000 doesn't mean they're not owed to you. There's no other way to get it. It's just, you just have to talk to an attorney and see the best way to go about collecting that. Okay. Let me give you some suggestions on some options on what you could do to protect your lien rights for that June invoice. Option 1, we can edit this. This release covers a progress payment for all labor and services through August 31st. Everything in red is what I've added, with the exception of invoice 4545, dated June 30th, with a balance due of $12,000, period. This waiver does not cover any retention, pending modifications, and changes or items furnished after that date. Okay. I like this way because it mentions the invoice number, the date of the invoice number, and the balance due. Okay. Another option, take out the word through and say this release covers for invoices 5656 and 6767. Those were the July and August invoices only. and does not cover any retention. So take the date piece out and add for invoices. Another option, if you don't have a way, PDF, maybe Adobe Pro or something like that, you don't have a way to edit your waivers, you can always put an asterisk in that field and say, see attached or see note below. And you can handwrite in and say, this is for only invoices, 5656 and 6767. It does not include invoice from June and the balance still owed is $12,000. You can just handwrite something in there or have an attachment. All right. Now we're going to get into this dispute amount that shows up on final payment waivers. This is rarely used. I have not seen it. I had a conversation and a meeting with a construction attorney as I was preparing this, and we learned a lot. We both still learned quite a bit, but most of the waivers that we see on final payment, there is a $0 in the field for disputes. But we are going to do a dive into examples of when you would use it, because it's on the waiver and there's a lot of questions around it. So we came up with a scenario to share with you. I want to just go back to the definitions really quick and just reiterate. A dispute means that an owner or a contractor must have actually disputed and must be continuing to dispute an obligation to pay for charges. Extra work means a change order. Okay, with that in mind. The unconditional final payment waiver has this is supposed to be red right here, sorry, has two things to be aware of. It's a full waiver on final payment with an exception, except for disputed claims for extra work. Okay, except someone's disputing some aspect of it, and it's for extra work. It's tied to a change order. Okay, so I'm going to tell you a story. If you read this, you can read along, but I'm basically going to read through this. I hate slides like these. I was really struggling with these slides because there's just so many words. But anyways, here's the scenario. A paint supplier provides additional paint to a job site as part of a change order request from the subcontractor. The paint was opened. It was made sure it was the correct item. It was accepted by the subcontractor that does the painting, and they accepted it, right color, everything. Well, then the paint was stored outside. So first of all, it was opened. Elements can affect the paint as soon as it's open, and then it was placed outside in the heat. They thought they were going to use the paint a little bit sooner, but it was like 2 months later when they actually opened up that paint and started painting. Well, the owner saw that the paint color is not right, complained about the color, and required the subcontractor to get the correct color paint and repaint the walls. The owner refused to pay for the cost of the bad batch of extra paint and refused to pay for the cost of the labor to repaint the walls. Seems reasonable. Somebody's fault, though, right? There is a dispute. The subcontractor that ordered that extra paint, they demanded that the supplier replace the paint at no cost. Well, the paint supplier refused because the paint was accepted and it was perfect. The problem is it was placed outside for 2 months in the heat, and that can affect the color of the paint and damage the paint. Well, the subcontractor just did not pay the supplier for the paint, and it went bad, and they did not pay for the paint that went bad. And they actually went to another paint supplier and finished the job. So the job is now complete, and the original paint supplier has already been paid for everything except for this change order portion. And the supplier has been asked to provide an unconditional waiver on final payment for the payment he has already received. But there is a dispute from a change order. Therefore, this is an example of when you would use the dispute. You're getting pressure from the GC, from the owners, from the lenders to get finals on all of these from all the suppliers. There's a lot of pressure, and they're never going to agree to pay for it. You don't want to lose your lien rights on that change order. It's $16,000. That's a lot of money. But it becomes a business decision. Do you sign the unconditional waiver on final payment to appease everybody, and yet still retain your right to go, your payment right for claim for payment and any rights under a similar ordinance to go after the 16,000? So this is where you would use it. There was a dispute. It was for a change order. This is when we believe it could be used. Okay, so I'm going to go over, this was an unconditional on final. Now we're going to go over to the conditional on final payment, and talking to the attorney that we were brainstorming with, we don't understand if this is, if that extra work was meant to be in that other template or if it was left out of this one, but it's not in this one. So this just says, except for disputed claims. It doesn't have to be part of a change order, the way it reads, okay? Mistake or not, overlook or not, this is the law. So this is what we use. So the scenario based on this template, we're going to use a similar scenario, just change it up a little bit. But this is what's interesting. There's a difference between the unconditional on final and the conditional on final. The unconditional on final payment, the disputed claim amount field, is primarily used when a GC or an owner has a dispute to a PO or an invoice that is part of an extra work or a change order. Now, on the conditional on final payment, this allows for any contractor or supplier that is experiencing disputes from any party up the payment chain to use the disputed claim amount field for any services or materials incorporated into the project and does not need to be part of a change order. So we're going to give a scenario about that. This is example B, but we're going to use a similar scenario. We're going to go to the beginning of that same project, and we're going to say the damaged paint was part of the original PO. So the paint supplier, Cactus Paint, filled a PO from the subcontractor for $30,000 worth of paint. Some of the paint was damaged from the heat as it was stored outside, and the subcontractor is disputing the 10 gallons of paint at a value of $5,000. The job is now complete, and the original paint supplier has not been paid the $30,000 worth of paint supplied because of this dispute. Well, the supplier has been notified that there is no intention to pay for the damaged paint, and they are demanding a conditional waiver on final payment for the amount of $25,000, the amount they're going to pay. So this basically becomes a business decision. They're going to pay me $25,000 now. I really need that money. And you know what? Maybe I'll just put the $5,000 in a dispute so that I still have some type of, I'm not waiving that $5,000. I still may have some recourse in getting that back. So this is when you could possibly use the dispute. So this is a conditional waiver on receipt of the undersigned of a check from Allstate Painting in the sum of $25,000 payable to Cactus Paint. And this release covers a final payment to the undersigned for labor, except for disputed claims in the amount of $5,000. So you can do that and maybe talk to an attorney about how you can go forward, the best practices going forward in going after that disputed claim.